That's right. We're recording this. If anyone's wondering, we will be recording tonight's presentation as well.
This will be available on the ACIDS website on demand. And if you have any questions on how to access that, please email us at orangecounty, one word, @acids.org. I also want to thank Deja Miller, who worked with me tirelessly to get everything taken care of. And she will be the one sending out the CLE information within the next day or two. Deja is absolutely phenomenal. I just wanted to recognize her before we get started.
Introductions. So all of you might know by now that Phil Favro is our presenter tonight, and I have 4 paragraphs of his accomplishments, but we're not going over that. Phil is a straight up what you see is what you get kind of guy. I will tell you what his highlights are. Phil's practiced law for more than 20 years. I know it looks like he's a new lawyer, but trust me, he says he's practiced for more than 20 years, both in Northern California and in Utah. He has advised a variety of clients regarding business disputes and complex discovery issues. He serves as a consultant, special master, and expert witness. And with that, I am going to let him steal the show and go over his additional accomplishments and what he is here to talk about tonight.
Thanks, June. Thanks. Let's go ahead and get started with the content of the presentation. So a little bit about what we're going to talk about today, hot topics in eDiscovery. And if you came on last year, you know that this was the subject we covered last July, hot topics. So what are the hot topics this year? We're going to spotlight several new eDiscovery issues, and we're also going to talk about some issues surrounding ESI spoliation sanctions that we feel like this group really should know and be aware of. And as everybody has told you so far, we welcome your questions. I want to hear from you. We want to hear from you during the program. I'll do my best to answer the questions in midstream. So let's keep going with the discussion of these new discovery issues. You may look at some of these and say, hey, look, these aren't new at all, Phil. Come on, give me a break. But my sense is they are new. You have courts increasingly turning to forensic exams to deal with discovery chicanery, discovery obfuscation. You have courts insisting that parties now look at all the proportionality factors. We'll get into more details on that. The question of whether linked documents should be produced in family relationships. Boilerplate objections, do they finally merit sanctions? Yes, we'll get into that. It's only been almost 6 years since the changes of the Federal Rules of Civil Procedure made substantial variations in what practice is supposed to be on that front. We'll talk about the so-called mixed messages with Slack productions and why we're not getting consistency in case law. And we're going to talk about privilege logging and also data breach reports. Are they privileged or work product? So with courts increasingly ordering forensic exams, keep in mind that traditionally forensic exams have been considered a disfavored remedy, right? We don't want to allow you to take the other side's phone or computer, take an image of it, take it out, the control of reviewing the information out of somebody else's hands or the ability to review. And what we're seeing is that this rule, it's still a disfavored remedy, but courts are turning to it much more quickly. And a good example of that is Judge William Matthewman's decision in Measured Wealth Private Client Group. And look, when we go through these cases, I'm just going to give you the very salient facts so we don't bore you to death with a lot of real detailed information. So let's keep it high level. In a nutshell, the defendant in this case had agreed to turn over text messages and iMessages off her phone. And then for some reason, she got off the rails and said, well, no, I'm not going to give this to you. Maybe I will, maybe I won't. And the court said, look, we need to put an end to this dispute. We need to get forward with the merits. So what you're going to do, defendant, is you're going to turn over your phone to a certified forensic specialist. This forensic specialist is going to take a bit-by-bit image of your phone. I'm not going to let the plaintiff just look at your phone and the contents of it. Instead, you're going to have a chance to go through and mark stuff that's relevant, stuff that's not relevant, that you get to hold back, and privileged information as well. But this is our way of ending this discovery dispute, which has been going on too long. So the court is not necessarily disregarding a party's right to look at the information. But what they are saying is, the court is saying, we're not going to deal with obfuscation anymore. Let's get everything out into the bright sunlight so we can see what's there and then decide whether it has any pertinence for the merits, summary judgment, settlement conferences, trial. So this is not just one case. There are multiple cases to this effect, and keep this in mind as you're going forward, whether you're on the left or the right side of the V. Now let's go on and talk about proportionality. You might say, I've heard all about proportionality. There's not a thing you could interest me in regarding proportionality. Well, I'm sorry, but there's plenty to talk about in proportionality. Once the 2015 amendments went into place, restoring proportionality to its rightful place as one of the touchstones of discovery, what we saw was an increasing weaponizing of proportionality by requesting parties and responding parties. Responding parties would assert any number of boilerplate, ridiculous objections. This discovery is disproportionate to the needs of the case. It's not proportional. We're not going to give you anything. And then not substantiating that. You would have requesting parties saying, hey, we want everything and it's proportional. But what it really is it's just exceptionally relevant. And proportionality means that as long as it's really relevant, we get whatever we want. And we've seen parties weaponize proportionality in this fashion over the past nearly 6 years. Well, we're also seeing courts push back on these particular trends. What the courts are saying is, both parties, you really need to take a look at proportionality long before motion practice, number one. But number two, look at the discovery through all 6 proportionality factors. It's not enough just to simply say it's a gut feel, it's just disproportionate, or it's proportional on a gut feel. The Weidman case is a good example of this. So this is Judge Elizabeth Stafford, magistrate judge in Detroit. And Judge Stafford had taken a look at discovery from a very good plaintiff's firm and had said, now look, I know you have taken a look and told me how relevant this information is that you want to get from Ford. But like many attorneys, you've just simply glossed over the operative rules requiring an assessment of proportionality. You've just said under Oppenheimer, the 1978 Supreme Court case, that relevance is broad. Yes, it is broad, but it's also tempered by notions of proportionality. There was no in-depth analysis of the 6 factors. The fact is that Ford had already made a substantial amount of productions. This issue, it wasn't exceptionally clear how needful the information was for the plaintiffs, despite their claims of relevance. And the court ultimately felt like, look, if we go and make Ford redo some of the searches they've already done with the search terms that you're requesting them to run, this is going to be a waste of time for them. We feel like all of the operative documents have been produced that really bear on the claims of defenses. Oh, sure, there could be more out there, but the court said you haven't made out your case to show it's proportional. Judge Stafford's opinion is not the only one like this. I recommend looking at any of the opinions that Judge Jeffrey Cole has issued out of Chicago dealing with proportionality. The Velez case that he has issued in May, along with several other cases, hit on this idea of de-weaponizing proportionality, getting parties to look at all 6 factors of the proportionality analysis and being able to make a substantive assessment of whether the discovery is meritorious or not. That is what I see as an increasing trend on the proportionality front. So another key issue, and I'm sure some of you have heard of the Nichols versus Noon case, is the idea about whether linked documents should be produced in family relationships. Okay, what am I talking about? Well, traditionally, right, if there's an email and there's an attachment to it, it's a PowerPoint, right? I sent to June and to Grady and to Marla a couple of days ago, actually yesterday, this PowerPoint presentation. My email is the parent. The PowerPoint is the child. If it had to get produced in discovery, it would be produced in that family relationship. I don't know what it would be relevant to, but let's just take that for granted. So the question becomes, this is typical to produce emails and attachments in a family relationship. Is it also customary to produce an email or a Teams message or a Google message or a Slack message in a family relationship with a hyperlinked document? There is no document that's attached to the email. It's a document that's in cloud storage, could be in SharePoint, it could be in Google Drive, it could be in Dropbox, it could be in Slack, it could be someplace like that. You have linked to the document. Is there a reason why this should be considered the same? Some people say yes, some people say no. In ICVIA versus Viva Systems from the 2019 timeframe, so 2 years ago, the special master, retired Judge Dennis Kavanaugh, he said, yes, it's indistinguishable. The court in that case, or the special master in that case, had pointed to a case from 10 years earlier, which had said emails and attachments need to be produced in family relationships. The special master said, I fail to see the difference here. Linked documents, they're linked to and they're referenced in the email just like an attachment. Where's the difference? Produce the 2,200 documents at issue in family relationships. Nichols versus Noom, with Judge Catherine Parker being the magistrate judge issuing the first opinion, and Judge Lorna Schofield being the district court judge issuing the opinion affirming Judge Parker's order, begged to differ. They felt like it was disproportionate to the needs of the case to require the production of every single linked document. And there were some strong opinions issued from the eDiscovery industry as to why the court should go the way of ICVIA and not the way that it did. That, look, we've got to have this sort of relationship. Look, we've got to preserve these things how they are. We've got to keep this type of traditional relationship. But Judge Parker said, look, I mean, besides what might have happened in the past, in this case, what's proportional to the needs of the case is that Nichols and the fellow plaintiffs point out the documents that they feel are important, the documents that they cannot link up with the underlying messages, and the defendants will do that for them. But there was no showing that the defendants need to do that for every single document. And admittedly, there are differences between a linked document and an attachment. We're not going to go into all those differences at this time, but just consider the fact that the linked documents may not exist. Permissions may have been disabled that originally allowed the person to share it, and so forth and so forth. I've dealt with this issue as a special master, and the way that I handled it in one of the cases in which I've been involved was similar to the Nichols versus Noom matter. That's not to suggest that ICVIA couldn't have precedential value, but my view is that Nichols has the better view of the issues. You may disagree, it's fine. We can agree to disagree, or we can keep talking about the issues. So just know that there are differences of opinion. The Nichols case has a much greater and deeper rationale than ICVIA does. In any event, there are competing opinions on that particular issue. And for our organizers, I'm going to pause for station identification to see if you have any questions at this time for me to answer.
I did not see anything in the chat box yet.
Then let's keep going. Thank you very much. So let's take a look at boilerplate objections. You may say, Phil, what could be new about boilerplate objections? They're as old as discovery itself. I'm sure in Hadley v. Baxendale, that old chestnut of a case from the 1860s in England, talking about consequential damages, that somewhere out there were boilerplate objections issued by the defendant as a responding party to the plaintiff. But away from Hadley v. Baxendale, let's go to 2021. Let's take a look at what courts are saying. They're saying that it's been many years now since the federal rules have been amended. You've been warned long enough. If you're going to engage in gamesmanship by putting nonsense, frivolous objections, we all have seen them. In fact, many of us have probably drafted them in a prior life. I have. In a prior life, I put in the mandatory. They were mandatory at firm practice. The general objections had to go in. It may have been A through Z. It may have been A through double Z. And you know that we were listing every and all and incorporating them by reference into our discovery responses. But that practice in federal court has been forbidden, outlawed, prohibited. And with so many warnings now, we're seeing courts issue sanctions. In the Blair case, the court issued about $10,000 worth of sanctions because of the boilerplate objections that were repeatedly imposed to plaintiffs' requests for discovery. The court felt like, look, these issues and also other chicanery in which the defendant engaged, like, oh, we're going to produce these documents, and then the documents were never produced. When the defendants did this, the court said, I've got to meet this sort of behavior with sanctions. And you might say, Phil, $10,000, it's a drop in the bucket. It's something. It's more than what we were seeing before. This is not the only case. There's Hall versus Marriott, just a few miles down the road from Orange County, right in San Diego, actually. And with the Hall versus Marriott case, you have Judge Allison Goddard, practiced on both sides of the V, did plaintiff's class action work, also worked for Cooley. And Judge Goddard in this particular case, she said, look, this case involves classic asymmetric discovery, classic asymmetry. We have a defendant with all the information, plaintiffs with none. This disincentivizes the defendant from cooperating. The problem is when the judge gives straightforward instructions on discovery responses and the defendant does not adhere, it tends to violate Judge Andrew Peck's rule number 1, don't anger the judge. I think that's what happened here. And Judge Goddard ended up imposing about $25,000 worth of sanctions. Again, you might say, Phil, it's a drop in the bucket, $25,000. No lawyer wants their client to be sanctioned that amount of money, not even $1,000. It's such a bad look. And in this case, the judge went through any number of boilerplate objections, particularly the unduly burdensome objection, and put the lie to almost all of them. And in particular, there was one set of requests in this case where the defendant had said, you know, it's going to be unduly burdensome for us to turn over financial records, financial information, revenue streams from our franchise hotels. You know, we really can't get access to that information. And Judge Goddard said, that's just not true. That is ridiculous for you to say that because you can get any paperwork you want from these franchise hotels. In fact, Judge Goddard did a simple internet search during the hearing on this matter and pulled up a franchise agreement right in front of counsel, confirming that they had the right to get this type of information. That's one of those, oh, we're not in the 1995 era anymore. The judges can just go and do that. I'm going to show you 2 other cases as well where judges just did that kind of research on the fly. Okay? You can't fool them. You can't fool the judges on those particular issues. All of us know how to do an internet search now. So the defendant said, it's not within my possession, custody, or control. The court said, yes, it is, because you have a legal right to get the information. And this is a legal right state and a legal right jurisdiction. The court said, not only was that objection lacking merit, but it was frivolous given what you knew was in the franchise agreements and given how easy it would have been for you to turn over the information instead of submitting on the eve of motion practice some sort of lengthy declaration which completely avoided the issues and obfuscated them. These are 2 of many cases that we're seeing sanctions being imposed in the monetary nature. Be aware of those going forward. Now, Slack. Mixed messages regarding Slack. Yes, it's a terrible pun, but I had to put it in there because we are seeing this. There are more cases coming out about how to address the production of Slack data. That's good. But what's not good is that it's a complete mixed message. You've got cases all over the place. If you were to have a Slack/discovery dartboard, the darts are not coming anywhere near the bullseye of where they should in terms of addressing these issues. And the Lobb versus Orbashevsky and Benebone versus Pepquirk's cases are great examples of this. They're on opposite sides of the dartboard. Let's take a look at the Lobb case from about 8 months ago. In that case, you got a couple of court orders. The first court order 3 years ago, the court said, look, the defendant has a standard Slack account. Plaintiffs want to get information out of there, but I'm holding that the information is not reasonably accessible, number one, under Rule 26b2b, and number two, the defendants don't have possession, custody, or control over this data because they can't get it from Slack. And the court basically 3 years or 2 years later in November 2020 affirmed its own ruling when the plaintiff moved again for the same relief. Now, you might say, well, what's the big deal, Phil? Well, the opinion, especially the August 2018 opinion, but also the opinion from 2 years later, they just aren't that well reasoned. Let me go into why. With Slack messages, the defendants had a standard account. Standard account allows the defendants or anybody using a standard account to get, as a matter of right, messages from public channels. There's no doubt that those messages belong not only to the defendants or to the user, but also that they can be obtained with relative ease. Producing them, not as easy, but having a right to get them, easy. A little trickier is getting the private channel messages and the direct messages. Okay, you don't get those as a matter of right. You got to ask for those as the user. But the court didn't look at those nuances. The court just simply said they don't have possession, custody, or control. Slack has the messages. The defendants don't, so they don't have possession, custody, or control. I'm sorry, that is not a correct decision. And to uphold it 2 years later is compounding the error. But I don't put the error at the fault of the court. It's not the court's fault. Fault is plaintiff's counsel not using any sort of tactic to get in any sort of information about how Slack works. They could have brought in eDiscovery counsel and associated in an eDiscovery counsel to have argued the motion and put forward better arguments on the issues and briefed them better for the judge. They could have brought in expert consultants to have briefed the court through expert testimony on these particular issues. They didn't. And so I put the fault at the feet of counsel and the client for not doing so. Whenever we see these expert discovery issues, or excuse me, these new data source issues that are not appropriately briefed for the court, I put the fault at counsel's feet and the party's feet for not engaging an appropriate expert or appropriate counsel to help them explain it to the court. So
we have a question.
That is on the one side. Now, we're going to talk about the other polar opposite. We have a question?
I do. Peter Bennett wants to know, is there any evidence so far that some internal or external nefarious actors are using Slack more now within or out of the office since people aren't as educated and working with it yet?
Now, as opposed to 15 months ago before the pandemic, I mean, everybody knows that these workplace collaboration tools have proliferated, but are they using them to engage in chicanery more now than they were before? Hard to say. Hard to say on that front. I mean, it's getting away from the case law presentation. I can tell you, Peter, that companies are particularly concerned about the opportunities for wrongdoing that can be committed on not just Slack and Teams, but on iMessage, Wickr, Snapchat, and so forth. Is there a greater risk of it now that we have been remote, and with the current developments, we may end up staying remote for a while? Sure. But all I can tell you is a general sure at this point. So appreciate your question on that. Let's go ahead and let's look at the polar opposite now, the Benebone case. So Lob is way out here. I don't think it's good law. Benebone is way out here. I also question its rationale. In Benebone, you have PetQuirk saying Benebone has relevant information in Slack. We want to get it. Benebone says it's too difficult. It's not reasonably accessible. We can't really turn it over. PetQuirk's, unlike Lob, the plaintiff in the other case, PetQuirk's engages an expert. His name is Mike Gutierrez. He's actually very good at what he does. I've worked with him as a special master before. Mike comes in, introduces a couple of declarations. Court reads them, says, the expert said so. I'm going with what the expert said. It's discoverable. and you ought to be able to turn it over, Benebone. Did Benebone or its counsel provide a counter declaration, a rebuttal declaration? No, they didn't. Unbelievable. That's the exact same point I made before. You've got to be able to substantiate your position with expert declaration, explaining how the technology works for the judge. If an expert from the other side is going to put it forward and you don't rebut it, it's a good chance the court is not going to accept your version. But here's the problem I have with the court's opinion. The court said, hey, Slack is just like email. Of course you need to produce it, as long as your requests and searches are appropriately limited and focused. Slack is not just like email. Getting data off an Exchange server or off of M365 is turnkey easy compared to getting it from Slack, especially getting it in the right form, organized properly by custodian, by date, and so forth. Nothing is turnkey about working with Slack in this way. So I feel like, wait a minute. Yeah, I think it's the right decision in terms of requiring a production, especially with limited and focused searches. But I disagree with that particular rationale that it's just like email. It's not just like email. So be on the lookout for additional Slack cases. Let's see where they turn up. And just one last point about this for our Southern California audience. Most of the Slack cases, 4 very important Slack cases, including these 2, arise out of the Central District of California, right there in Orange County, Los Angeles County. So among other places in the Central District. We're not done with workplace collaboration tools. Let's talk about Microsoft Teams. There's very little case authority out there, almost none, on the production of Teams data. And recently found this case from earlier this year. It's from Delaware Chancery Court. And I'd say this is one of the most important business courts in the nation. Take a look at this case. Unfortunately, there's not a specific production order that relates to this particular issue. Instead, the order that you see up there is a sanctions order that's basically summarizing some of the discovery chicanery in which Optimize engaged over the course of this litigation. The court ended up issuing sanctions against Optimize. As part of that, it talked about Optimize producing Microsoft Teams messages. Now, any of you who've dealt with Teams know that when you look at Teams, you're looking at a set of chats, right? Whether it's in a channel or in the chat feature. So however you slice it, what's reasonably usable is producing chats as they would appear between 2 or more people. You could slice it by day, by week, by month, however you want to do it between the people in a chat. That's not how Optimize produced them. They TIFFed every single one of the messages so that it produced 87,000 separate emails as 87,000 separate emails. They weren't emails, they were the individual messages. And some of those were attached to Charter's expert declaration. And I looked at one of them for an example, just one line of text like you'd expect to see. Imagine looking at, let's just say an iMessage conversation over a year between 2 people going back and forth. There'd be tens of thousands of individual messages. That's not a reasonably usable format. And Charter said, look, you've got to produce these in a format that we can actually see them in context. And Optimize was told it had to produce them in native to do that. Optimize declined. The court said, yeah, you are going to produce them in native because they need to be seen in conversations. This is a joke what you've done. It's an absolute document dump, the way you've done it. The lesson from this is not produce in native, in my opinion. The lesson in this is, if you're the responding party, produce in a way that slices up the conversations, whether it's by week, by day, by month, hopefully with the agreement of the other side. That would be useful so that you don't have to fight over this after the fact. Produce them in TIFF with metadata databases, but produce them as conversations. So that's my opinion about the Teams case. June?
So Grady decided not to unmute himself, and he has a question that is not case law relevant, but he wants to know if at Driven, y'all use Slack or Teams, and how do you like it from that perspective?
Oh, meaning, do we use it in our work environment, or do we handle it from a discovery perspective?
Do you use it in your work environment?
We do use it in our work environment. We use Teams in our work environment, and it's a very useful tool. And is it better than Slack? Is it worse than Slack? I can't say one way or the other. I mean, there are features that are better about Slack, that are features that are better about Teams. So anyway, we're not alone. There are tens of thousands of users out there growing day by day. So anyway, any follow-up questions on that?
No,
Okay.
I think you're doing a great job. Your slides are really helpful.
Terrific. Terrific. Thanks, June. Well, let's keep going with privilege logging. So privilege log, the bane of everybody's existence, right? I've done privilege logs for years, and I've litigated privilege logs issues from the left side of the V. I'm kind of the stone in the shoe, or was at one time, for the other side in a very large False Claims Act case. I'll put it that way, where I felt like the privilege log was just garbage, and we needed to get more transparency on documents that we felt like were withheld. Well, let's take a look at privilege logs in 2021. If I had to go back and do it all over again, I'm not sure that I would have pursued that so aggressively 12, 13 years ago. I'm not sure that tactically it made sense and was worth the money and time. Many courts and litigants feel that way too now, but many don't. Many courts complain about in-camera review, and yet they grant it as a matter of course to look and determine whether documents are privileged or not. But I was pleased to see the Weir versus United Airlines case and a couple of other cases out of the Northern District of Illinois, Chicago, and the greater area, where the courts were taking a little more of a serious look at an in-camera review question. In Weir, the court said, look, the answer in this case isn't for me to review a bunch of documents in camera. In fact, there weren't very many documents that were in dispute, only about 35 or so. The plaintiff had said, Your Honor, there's only like 35 messages at issue. You can review them like this. In-camera review, Your Honor. And the judge said, look, I'm not going to do this for expediency's sake. Just because you want an in-camera review doesn't mean you get one. It doesn't mean you're entitled to one. He said, what we really need to do here is just improve the defendant's privilege log. Go back, United Airlines, do it again. If you do it right, and it looks right, and it's done right as a log, guess what? That's the end of the inquiry. We don't need to have privilege log litigation overwhelm and swallow merits litigation. And so Weir provides an interesting perspective on the issue. Yes, in-camera review is needed a lot of the time, but is it really needed all the time? It's a good question to ask the court on this particular issue. So this to me is definitely a new trend to see that judges actually pushing back on the notion of in-camera review. Now let's segue to our last new eDiscovery issue. Are data breach reports privileged or work product? Great question. What do you all think? I'd love to have a poll on this. I should have probably put one together. It'd be very interesting if we were a live television studio audience like we had in Laverne and Shirley all those years ago. I would probably take your poll and find out. June, you've come off mute. Maybe you have a response.
Well, I'm going to say this for all of you who say that it is privileged or work product, just show a thumbs up. If you think not, from that reactions bar, right? You can do, I don't know.
Well, that's all right.
So well, we could definitely have a thumbs up. Look at that. We have a hand up. Peter Bennett's hand is up. So I am believing that we have some people who think yes. Look at that.
Okay, great. Thanks, Jude. So,
yep.
So appreciate that. And let's take a look at this a little more closely. I've got a couple of no's up there on the screen. There are a couple of cases from a few years ago where we've seen courts find that breach reports, basically reports generated by security professionals engaged by counsel to ostensibly help them rendering legal advice to the organization. The court in the Target case, a very noteworthy case from 2015, and then a few years later in the Equifax case, found that particular data breach reports were privileged or work product. But in the Guo Wengai case here in the lower right, and in the Rudders case on the lower left, the court said no. No. And let's look at some of these distinctions as to why. So with Rudders, Kroll was engaged to provide essentially an assessment. What happened? And ostensibly for litigation purposes. But the court said, let's take a look at the statement of work between Kroll and counsel. Well, it's actually not with counsel, it's with the defendant. That's kind of a problem. But okay, getting beyond that, let's take a little bit deeper look at the statement of work. Oh, the statement of work indicates that the primary purpose is to figure out whether the data has been compromised and the scope of that compromise if it's occurred. There's nothing legal directly about this. It's for an important business purpose. Legal issues are collateral. Where the primary purpose of the communication is not for legal purposes, but for business purposes, it's not going to be privileged. And for the same reason, the court said it's not been prepared in anticipation of litigation. Take a look and compare that to the Equifax case. In Equifax, from a few years ago, the security professionals were engaged by outside counsel, not by the defendant, number one. Number two, they were engaged for the specific purpose of helping counsel render legal advice. And number three, the report was shared only with counsel, not with IT, not with business professionals, not with people outside the organization. So all of those things made the Equifax report privileged, and they made the Kroll report not privileged. Similarly, in the Wengai versus Clark Hill case, the professional malpractice dispute against Clark Hill engaged two different providers to provide them with advice. They engaged eCentire, and they also engaged Duff and Phelps. And Clark Hill said, this is just like Target. We engaged eCentire to essentially provide us with advice on how to handle the business issues, right? Scoping the business issues that relate to the breach, how to remediate, what recommendations can be had for the future, blah, blah. And we had our outside counsel engage Duff and Phelps for legal purposes. The court said that's a nice story, but that's after the fact, litigating. They said, yes, Baker Hostetler, your outside counsel, did engage Duff and Phelps, but not for legal purposes. At least that wasn't the primary purpose. As you look on the screen, the primary purpose was to apparently shield material from disclosure and discovery. And the fact is that Clark Hill was in there. The primary purpose of their involvement was also to provide business advice, how to handle what's happened in the breach and what can be done to remediate it in the future, what can be done to mitigate damages. And they provide a number of recommendations. Those are all business reasons. None of those were legal reasons. So the court said it wasn't prepared in anticipation of litigation. There isn't anything privileged about this. Its primary purpose was not to render legal advice. And moreover, you've disclosed this outside kind of the legal field. You disclosed this at the company IT. And in addition, you disclosed it to the FBI as part of their cybersecurity investigation. All of that suggests that it's not privileged, it's not work product. So keep an eye on this. If you want to be able to consider your data breach reports privileged, look at the Equifax case, look at the Target case, or learn the lessons from these two cases. So those are all of our issues that we wanted to cover on the new front. And I wanted to see if we have any questions or comments from the audience before I carry forward.
No questions. People are loving your presentation.
Okay, great. So let's talk about ESI spoliation sanctions and issues surrounding these sanctions that are of interest. So we're going to talk about issues that are somewhat new as well. But you may say, well, I've heard this all before. I don't think so. We'll talk about reasonable inquiry, and we'll talk about the need to take effective preservation measures. Yes, we have heard that for years, so I can't disagree with you on that. We'll talk about Snapchat, emojis, and also ESI evidence issues and ethics issues. So let's keep going. Okay, so the duty to perform a reasonable inquiry. This is not a new issue, but what we're seeing is courts paying closer and closer attention to this. I've put up two courts cases where the courts particularly looked at the duty of reasonable inquiry, but this is the tip of the iceberg. Courts have been considering this issue over and over and over again this year. And take a look at Access Insurance. There were no sanctions issued in this case for the loss of information, but the court said, you have not performed a reasonable inquiry, American Specialty defendant. It's not clear. You've got conflicting stories about your production of emails and communications. And with the conflicting stories about, well, how you've performed a diligent search, but there's a paucity of communications that you've produced, and other evidence suggests that there are legitimate concerns about whether your search methodology was sufficiently broad to encompass the responsive information. We're going to order you to go back and look at your client's documents, search the repositories, and provide me with a sworn declaration on all you've done. The what, the why, and the how, all three. So no sanctions, but a very strong discovery order on this. And I'll be interested to see what they end up coming back with. This opinion is a month old, 30 days old today. Now, opinion that's about 9 months, 8 months old, I should say, is a DR Distributors case. And if you tuned into our ACIDS broadcast back in April that I did for the Detroit ACIDS chapter and was, I think, broadcast nationwide, we talked principally about this case and essentially a breakdown in the reasonable inquiry stage by the defendants and their counsel caused untold numbers of communications from GoDaddy, Yahoo, and Yahoo Chat to go missing. Communications that were relevant, that were not just marginal, but material to the outcome of this litigation. And the thing that I take from DR Distributors and Access Insurance companies and various other cases is the need to go in to have a checklist that you supply to your key players, to conduct custodian interviews, and then to really ferret out all of your document repositories, right? Where the data could be stored and where it could have been communicated, where it could have been exchanged. Go in, make sure you've got a handle on that information so you can appropriately identify, collect, and then preserve the information. That is inherent with the reasonable inquiry. It's not just an issue with production. It is part and parcel, inextricably intertwined with preservation. Now, as we're getting the last 15 minutes of the program, I want to talk about a few other things. So the need to take effective preservation measures. You might say, hey, no kidding, man. We all know this. Yes, but it's important to see what's going on in this. Let's compare Gomez with Peel. So in Gomez, the defendant is sanctioned. Sanctioned because the defendant didn't take those effective preservation measures. Look at what's going on here. Gomez is the plaintiff in a wrongful termination case. Gomez receives an email with the subject, I hate. And it's basically, I hate you because of your racial group. So that's really a pleasant and chipper message to get. What did Gomez do with it? Did he delete it? Say, well, I'll just turn the other cheek. It'll all be okay. No, we don't do that in this era. Gomez forwarded the email to defendant's legal department. Now, that didn't mean that he was going to sue. I don't know that that would have alone put the defendant on notice of litigation, but Gomez also contacted the EEOC, and the EEOC let the defendant know that it was investigating this. Okay, it's not a right to sue letter, but we're starting to get a little closer, right? Number three, behind door number three was a preservation demand from Gomez's lawyer to the defendant. That, to me, behind door number three means litigation's reasonably anticipated. Hard to argue with that one, especially combined with the other issues. The defendant did not take any steps to preserve related emails beyond the I hate email. Court said that's sanctionable. You've lost all these emails. We don't have a fair picture of what went on. we're imposing sanctions under Rule 37E against you. Now, compare that preservation demand, which specified the request for those emails, against Peel's, where you have a loosey-goosey preservation letter. They obviously never read Craig Ball's top 10 tips for preservation demand letters that he authored, or whatever it was, back in 2008 or 2010. So you have a loosey-goosey preservation demand letter. The defendant goes in and preserves relevant video footage of the slip and fall that's at issue in this particular case. And litigation commences. Nothing really is said about video footage that's been preserved. And the letter, again, is not specific about what needs to be preserved. Somewhere, several months, a year, I can't remember how much into it, the plaintiff said, oh, you need to preserve all this other video footage. The defendant said, it's gone. Well, you should be sanctioned. That's it. You should be sanctioned. We should end the case. The court said there's no sanctions here. You didn't make it clear they need to preserve all of this footage or the connection between that other video footage and the accident. There was no, the information may have been lost under Rule 37E, but there was no duty to preserve it. Hence, there's no sanctions. So take a look at your preservation demand letters. If you're sending it out, whether you're the plaintiff or the defendant, plaintiff sends it out, we expect you to preserve everything. The defendant, okay, we live in glass houses, don't we, plaintiff? You better do the same. So whether you send out a preservation demand, consider what you're asking to be preserved. Be clear about it. And the broader and the more loosey-goosey the demand, the less likely the court is to enforce it. The more particularized and reasonable the requests are, the more likely you're setting up your adversary for trouble if they don't follow those steps. Okay, so brand new case. Okay, about 5 weeks ago, the Doe versus Purdue University case involving Snapchat evidence. So in a nutshell, defendants want Snapchat memories that the plaintiff has made. Plaintiff says, I don't know what you're talking about. Reminds me of The Godfather, the second movie. I don't know what you're talking about. There's no Don here. There's no memories here. I don't know what you mean. He actually testified in written testimony in court. I don't know what you mean. I don't know about memories. And so did his lawyer. Oh my gosh. I don't know no Don. I don't know no Snapchat memories. Guess what happened? The court found out, and the defendants found out, that he actually had like 85, 84 some odd memories he had saved. And yet he had submitted sworn testimony. Snapchat doesn't save any memories. I don't have any of this stuff. So anyway, the court said, you've got these memories, turn them over. I know you have them. And the defendant, or excuse me, the plaintiff said, sure, I'll turn them over. Turned over a lot of them, but not 11 of them. Okay, turned over 73 or 74. So the court said, where are the missing 11? Well, I don't know. They just, they weren't kept. I don't know what happened to them. But they disappeared between the court's first order requiring their production and the second order saying, you better produce or else. The court said, look, a superficial search tells us that these memories are not only kept, but if you delete them, Snapchat will delete them off its server too. You failed to keep relevant Snapchat memories. They are relevant. They are responsive. They're important to the defendant's defenses, to your claims. Sanctions are going to be imposed under Rule 37 for doing so. The real important lesson here is going to be on reasonable inquiry and what counsel didn't do in this case. Counsel just simply listened to his client and said, oh yeah, you're right. Okay, I believe you. Didn't undertake a reasonable investigation on his own to understand what Snapchat's retention features are with respect to memories. That was a problem, especially because the court undertook its own independent research in this case to find out whether Snapchat did or did not preserve information. And the court said, yeah, I figured it out. Basically saying, couldn't you figure it out? Court didn't impose sanctions, but did chastise counsel. It's a lesson to us as lawyers and litigation support professionals. Steps we need to go in and take to perform a reasonable inquiry. Snapchat should be on your custodian source checklist. You should ask about it if it's being used, more in-depth questions. So let's keep going. Let's talk about heart eyes emojis. This just came out last Thursday. Just goes to show we're trying to keep on top of the cases, special for this audience. So in the Rosbach case, you've got a party, the plaintiff, that fabricates a text message string, a salacious text message string, I might add, and puts in the heart eyes emoji and claims that she received this from a fellow employee, Morales. The problem is that she claimed to receive it on her old piece of junk iPhone 5 with a cracked screen and ink bleed and all these other, well, lies that she told. And that heart eyes emoji did not look and will not look on an iPhone 5 like it looks like on my screen and like it looked like in the fabricated email. You see, for operating systems below 10 for the iOS, the heart eyes are a lot smaller. The red is not nearly as deep and intense as it is for operating systems 10 and above, which the iPhone 5 could not run. In other words, the message that she showed had any number of problems, but the emoji was a key tip-off with these big heart eyes, which could never have been on the iPhone 5. The court just dismissed the plaintiff's claims last week. Claims dismissed, monetary sanctions imposed jointly and severally on the plaintiff, plaintiff's counsel, and plaintiff's counsel's firm. Ouch. And the court ripped basically plaintiff's counsel, saying, why didn't you look into this more closely? And especially once the defendant started saber rattling about fraudulent evidence, surely you should have looked into this a little bit more closely. Fact is that plaintiff's lawyer did not perform a reasonable inquiry and did not preserve data on the iPhone 5 or the plaintiff's iPhone X. Sanctions imposed, dismissal appropriate under the court's inherent authority and under Rule 37E. So, reasonable investigation, understand how these things work. Now, we're coming to the end of the program here. I've got two more cases I want to cover for you. Okay, we don't just go into discovery because discovery is interesting. We deal with discovery because we're trying to resolve cases, whether they resolve a summary judgment, they get resolved settlement conferences, or at trial. To do that, we need to have evidence that's admissible. Inadmissible evidence does us no good when we're trying to address issues on the merits. And the Edwards case is a good example of what happens when you have inadmissible evidence. This is, in all likelihood, another fraudulent message case. The difference being is it deals with Facebook Messenger messages. Edwards claimed, and I'm not going to go into all the detail about this, that he received messages that were racist and homophobic from somebody else associated with Junior State. Edwards took a screenshot of the message and produced it in discovery, but deactivated his Facebook account. Why would you do that? Well, could it be that you did not want to have the real evidence seen, what those messages really did reveal? I don't know. We'll find out at the trial of this particular case. But what we did find out is that the court said, look, this screenshot that you've produced is not a reasonably usable, it's not in a reasonably usable format. Okay, we don't see any metadata with it. It's just a pure screenshot. The court used the term native format, but I would say reasonably usable format, because I don't have Facebook's native software to be able to review these things. We want to get the Facebook Messenger messages in a reasonably usable format with the metadata so we can look at them on a platform. Okay, Edwards didn't do this. The court said, for purposes of Rule 37E, the message is lost. Edwards said, no, it's not. The message is here. Look, it's a screenshot. The court said it's not admissible. The court didn't deal with authenticity issues although I think the court could have gotten rid of it under authenticity rules, under the federal rules of evidence. The court disposed of it under the original documents rule, Federal Rule of Evidence 1001 at SEC, because it was not an original and it was a copy or duplicate, which was suspicious or not trustworthy, not admissible. I think it would have failed on authenticity grounds as well. So it was considered to be, the real evidence was considered lost, and the court imposed sanctions under Rule 37E. The take home here is, if you're going to be able to use the information, it's got to be admissible. You need to know that when you're collecting it. Screenshots may be appropriate, I guess, in certain circumstances, but oftentimes, as we see in this case, Rossbach, if it had ever gone to trial, or in Edwards, a screenshot is not going to cut it for admissibility purposes. So we're just about at the end of our program. I have an ethics issue for you. If you find out about a spoliation event as a lawyer or as a litigation support professional, how long do you have to investigate? How long do you have to sit on the issue before you have to disclose? Well, in DR Distributors, Judge Johnston said, certainly not several years like the defendants did in that case. And Judge Barbara Moses in Charleston Capital Advisors said, certainly not for several months. Ethically, we have responsibilities under Rule 3.3 and 3.4 to disclose and to not make misrepresentations about the nature of certain evidence or the lack of existence of certain evidence. When we have to comply with those rules, the disclosure for those rules is going to vary from case to case. My position would be there has to be a reasonable time to investigate, okay? It can't just be turn everything over right away. Counsel needs to know, is it even lost? Don't I have a chance to take a look at this? Is it days? Probably. Is it weeks? Some weeks? Probably. Is it months? Months, plural? Maybe not. Okay, certainly not months in Charleston Capital Advisors. It's going to depend on the particular case. Probably want to get an opinion from an ethics advisor. You probably want to consider it with eDiscovery counsel or experts on these particular issues. So those are all the substantive cases I wanted to cover. If you want more details on any of these cases, I've written a whole bunch of articles about them this year. In fact, over the past 8 months, you're welcome to look at those. Legal Tech News will be publishing my article on the Rossbach case within the next week about emojis, and I recommend you take a look at that. June, I've seen lots of people put messages up in the chat. Can I answer any questions that people have?
No questions. Marla and I did a bunch of housekeeping, but everyone has had just really positive feedback. Absolutely love the presentation. We let everyone know that this presentation would be emailed out to them so that they can take a look at the resources that you have listed. I also encourage everyone on today, if you have questions, you want more information, you are absolutely welcome to connect with Phil on LinkedIn. You can easily find him there. And I know we've had the LinkedIn conversation before. If you don't have LinkedIn, get LinkedIn. If you have LinkedIn, get on LinkedIn. Connect with individuals like Phil. They provide very valuable information to all of us, both new and seasoned in the eDiscovery realm.
Yep, and I just put my email into the chat. You can also email me there as well. But appreciate all of the kind comments. If you didn't like the presentation, gosh, let me know too. If you thought it was junk, I'm happy to improve for the future as well. So I welcome your feedback, positive and negative, so we can make sure we have a presentation that's workable for you in the future. But that's all I have today, although there are any number of other cases, and I welcome you to reach out to me if you'd like more information on them.
And really quick, don't forget that we are continuing this Saturday morning at 9 a.m. With a California roundtable regarding the 2020 law with California and eDiscovery rules. This is going to be led by our own Grady Glover, the Vice President of ACES. There's Grady, he's waving. Vice President of Orange County ACES and the eDiscovery Manager at Sanders and Roberts, right?
Yes, absolutely. And also featuring Joy Marai from her company, as well as Gareth Evans, who I think Phil knows pretty well, from
Yeah.
Redgrave. So
Gareth is outstanding. He's very accomplished, and I recommend anything he has to say. I recommend listening very closely from his time, nearly 30 years at Gibson Dunn, and now he's been at Redgrave for 3 years. He knows his stuff backwards and forwards. He and I were colleagues for years at the Sedona Conference Steering Committee for Working Group 1.
well, we've been very blessed to have both of you come join us this year again for our Summer Refresher 2.0 series. And I'm not taking over, so thank you. And June, go ahead.
No, I'm good. We have all of our announcements in. Again, a big round of thank you to Phil for giving up your Wednesday evening. And, you know, all of this was absolutely spectacular information. I'm super excited. I now have new stuff to read, so that excites me even more. But I think we covered everything. You finished perfectly on time. So thank you. And if anyone has questions, we put all of the info in the chat already for who to email. And we will see you all on Saturday. Come back and join us.
Have
Thanks
a good
very
evening.
much.
Hi, everyone.
Thank you.
Bye, everybody. Thank you.